In this video, we're going to talk about the 5 mistakes parents make during custody hearings. It's important to know what to do to put your best foot forward in court. About me, my name's Nathan Vining, and I'm a family law attorney in Indiana, and I'm going to give you advice on what to do to avoid these mistakes in your custody hearing. So the first mistake is poor preparation. Sometimes there's deadlines for when witness and exhibit lists need to be turned over, or when exhibits need to be filed with the court. Or even there's poor preparation around what exhibits you intend to introduce, and do you have the proper authentication or ways to get these exhibits into evidence. The second mistake is relying on inadmissible evidence. There's things like hearsay. Sometimes a parent wants to rely on something the child told them. You just can't go and say what your child told you in court. You're going to need a way to get that in. That can be through, for instance, statements of medical diagnosis. It can be through using your child's therapist to get your child's statements in, or even the guardian ad litem. The guardian ad litem can use hearsay, can actually talk to the court about what your child said. Another issue is unverified records. Sometimes you may have school attendance records or medical records. You actually need to have a proper authentication for that exhibit. It needs to have a certain business record foundation. So you can use that and get that into court. So you're going to want to work with your attorney. You're going to want to obtain verified copies of different documents that you get into evidence. You're going to want to have a plan to get around hearsay. So either have the person in court, or if you're going to be trying to get child statements in, have a plan on how you can get the child statements into evidence. Mistake number 3 is speaking out of turn. A lot of times someone can get frustrated in court. They can speak out of place, and that ultimately doesn't go well. A lot of times the judge can get upset, can admonish somebody for speaking out of turn. And another thing is they're speaking to their attorney while the witness is on the stand. A lot of times your attorney needs to listen to what the witness is saying so they can effectively cross-examine the witness or examine the witness themselves. Speaking out of turn to your attorney, a lot of times you will need to have a notepad there and write down questions. And for instance, I'll examine a witness or cross-examine them. And then before I conclude, I always consult with my client before releasing the witness. That way we can make sure there's not anything we missed. So rather than interrupting the flow of court, either through outburst or even just talking to your attorney while the witness examinations are going, wait for those moments where you have opportunities to consult and strategically work on the case together. And it can even be as simple as sliding notes over or waiting until towards the end when your attorney consults you, which they should do before they release the witness. And then mistake number 4 is not demonstrating an active involvement in the child's life. This is, if you're in a custody case, it's about your kid. So you're going to want to talk about some of the bigger things. The best interest is a broad standard. So a lot of times your case may be about limited issues, but I always like to start wide and talk about what do you do for work? How do your work hours impact your ability to parent? What's your home like? Is it set up? What's the community around the child? You want to make it about the child, and you also want to demonstrate your involvement in the child's life. A lot of times that can be talking about how your home's set up for your kid, how it's close to the school, how your family's nearby, things like that. You want to show an active involvement in your child's life and that you're making decisions that are in the best interest of your child. So mistake number 4 is just not showing that active involvement in the child's life. And that's even things like attending school appointments, doctor's appointments, parent-teachers conferences. If you're trying to get more custody, you want to be showing that you're doing all those things. That goes a long way towards showing the court that you're there, you're stepping up, and you're actually a person that should be getting more time with your child. Mistake number 5 is failing to put the child's best interest first. A lot of times that can be something that looks like getting in fights with the other parent that are unrelated to the child, not being the bigger person, things like that. So mistake number 5, not putting the child's best interest first. So ultimately, if you are looking for success in a custody hearing, a lot of it's about proper preparation, having the documentation, having evidence that can be admissible in court, and focusing on the child's best interest. So if you have questions about a custody case, give me a call today. I'd be happy to review your situation, talk to you about what we would do and how we could prepare a custody case to help avoid these mistakes. So here's my number. Give me a call or text me.